Yes, Mr. Green.
So we just got to the end of looking at the use of determine and comments in little 2. And I just finished saying to you, Your Lordships, that there's actuarial judgments permeating all the other uses of determine. And when you come to the power to determine, as I was discussing with Sir Launcelot this morning,
You dropped your voice, Mr. Green.
Oh, I'm sorry.
I don't know why.
I do apologise.
Yeah, not at all.
When one comes to the power to determine in 2, then it's plain for all the reasons that I've been developing this morning that judgment as to collectability should enter the equation, because that's the essential submission that I'm repeating to you again and again. The actuarial judgment as to collectability is inherent in the power that is actually conferred in 2 for all the reasons that have been developed. And when I've spoken about substantive discretion and the like, the focus of the submission at the end of the day is that in the context of this exercise and in relation to these particular powers and this particular usage in 2, the power to determine that's been conferred involves the ability to exercise judgment in relation to collectability issues and to take into account.
Why do you say the power rather than it's a duty, isn't it? I mean, it's
a duty to determine.
It's a duty rather than a mere power.
Correct.
But is also another aspect of this is, I mean, how far are we supposed to worry ourselves with the question, is the actuary acting in a fiduciary capacity, or is he just acting pursuant to his contract with the trustees? And as a feature of our contract, implicitly or expressly, he has to use his best professional judgment and act as a proper actuary would in all the circumstances. And is that sufficient protection equivalent to the fiduciary duties owed by the trustee when the determination has to be made by the trustee?
Yes. Well, that's a very interesting question, if I may say so. And I think, the way I approach this, when I first saw my own friend's submission in paragraph 50 of his skeleton,
yes, saying
the actuary is a fiduciary, I must say I sat back.
So it also feels wrong, doesn't it?
It does.
Yeah.
And I obviously had Lord Justice Millett in Armitage and Nurse ringing in my metaphorical ear. And what was going through my mind, we haven't challenged it, but now that it's coming out, was evidently, if you're looking at what the particular qualities of a fiduciary duty are, you're acting for the benefit of others, and you don't exercise the power in a way which, as it were, lines your own pocket, in a way which involves conflicts of duty and interest. Now, it may well be that those are hallmarks of what the actuary is doing here, but does it necessarily follow from that you'd call him a fiduciary?
Well, one doesn't need to if one gets a sufficient content for what he's doing out of the law of contract and his membership of a highly regulated profession.
Indeed, and I would say, and that's where frankly I've been in this case, and I was comfortable with the description of fiduciary because I didn't think anything particular might turn on it, to be perfectly honest. But in as much as something might be suggested to, I think actually he's not a fiduciary, certainly in the sense of the trustee. It may be that he's entitled to come to the court for directions because he is, if you like, an office holder under a trust, and just as a protector might, whether fiduciary or not, might be able to come to a court for directions, so he, as an office holder, might come for directions.
And I suppose there could be an initial issue as to standing, because if you're not a trustee properly so-called, by what right do you come along to the court and say help?
Yes, and it may be that you get help, and it's all academic propaganda, but it may be you get help from the trustee who says, look, I've got an actuary here.
Sure, in that case, a trustee would apply on your behalf.
Precisely,
yes.
And then you've got the issue. Yeah. Which, in an oblique sense, is what's happened here, because the actuary, apart from the fact that the trustee has gone all queasy in the face of this issue, the actuary has said, I can't do this. I can't certify for 74% contributions, which is what he thought the issue was first time round. And he's very, very unhappy at the idea of culling all future service benefits.
Yeah. But am I right that the relationship between the trustee and the scheme actuary is simply one of contract?
It's one of contract.
There's no sort of type of trustee like status imposed on a scheme actuary or anything of that kind.
No. I suppose that
it's like you go to a solicitor. It's basically a contractual relationship. Although I suppose they are or can be fiduciaries.
And then you get into the question, and this is why I didn't really want to get
Well,
into
that's
this.
the thing.
I'm beginning to sink, because you could say, well, he's an agent of the trustee. And then you get into the question of principal and agent type relationships, and what's the nature of those? Yeah. So, but I really don't, well, for your lordships, but I'd concluded, but that I didn't need to take issue with this.
Yes.
But
Well, speaking for myself, I'd quite like to be able to conclude that we don't need to bother ourselves with too much analysis here. If we get sufficient content for what's going on from the contractual relationship coupled with the professional status and obligations of an actuary.
Yes. Well, I have to say, and I'll stand corrected, obviously. I don't think I've previously seen at least a case which has suggested that the scheme actuary is a fiduciary. But you can imagine circumstances where a scheme actuary might line his pockets, but he's going to be held accountable
Well,
for
there's all
that.
sorts of ways of dealing with that problem, if
Precisely.
one hopes it never will, if it does arise.
Precisely. So I personally, subject to anything that might turn on this, I'd incline to say he's not to be regarded as a fiduciary, although he clearly has the sorts of duties that Lord Justice Millett identified in Armitage and Nurse. But again, when you say is someone a fiduciary, it's common to say, why are you asking the question, isn't it, in response?
But I did wonder why the question arises. And the difficult cases are where the individual, where there is a potential conflict between his personal interests and the interests of the people or the company to whom he owes a duty. But that doesn't arise here. Nobody suggests that the actuary is even thinking of acting in his own interests.
No, it's when someone's doing something wrong or on the verge of doing something wrong, and you're trying to tell them to put them back on the straight and narrow, that you try to identify what duties they owe, and in that context, a label might be applied to them. But I think, if I may say so, that the duties owed in this context would be sufficiently discernible without the prop of the label. Mm-hmm. But in answer to Lady Justice Asplin's concerns of this morning, if the actuary had concerns, I believe that they would be capable of being brought before the court, if only by a trustee who was being helpful.
My queries this morning arose mostly because of the question about if one labels this as a discretion, is that a discretion by a fiduciary? If he is a fiduciary exercising that kind of discretion, then one will think that he would be able to come to the court, but it all seems rather odd. So that's
Well,
how
can I say
it all,
thank you? Can I say
came
thank you
back.
very much for explaining that? I'm now on track with your ladyship. Also.
Sorry.
No, I'm sorry.
No, I was going to say if we've dealt with that point, I think you were on point 12, but
So sorry, my lord.
I'm sorry just to interrupt once more. Would somebody please, not now, but if you could hand it up a little later, give me the reference to where Mr. Green said this morning that the actuary, in his explanation of how he goes about things, refers to fairness.
Yes,
so
it's
if somebody
paragraph-
could stick that on a
It's
sticky, I'd be grateful.
B15234,
Thank you.
paragraph 5.2d.
I'm just going to write it down. Would you repeat it for me?
B15234,
Thank you.
paragraph 5.2d.
Thank you.
Excuse me. And then we move on to sub rule 4.
Is this point 13, as my lord?
No, I'm
Justice
sorry.
was-
a long 12.
apologise. I'm afraid it's
Okay.
a long 12, because what we're doing is we're looking at the uses of the word determine
Yes.
throughout Rule 21. So the second limb of point 12 is to look at the use of the word determine in sub-rule 4. And the expression determines and cognates is used 3 times in 4, in a way which is very interestingly to be contrasted with the word calculated, which is also used in 4. In one of the 3 cases where the word determines is used, it's what the trustee may determine, and plainly that is not a straitjacketed matter. Specifically in relation, I'll come to calculated in a moment, specifically in relation to the actuary and determination, as your lordships will be aware, the introductory words provide for determination of whether a remaining shortfall is to be regarded as trivial in the context of the section. As with the introductory wording of 2, triviality involves exercises of professional judgment targeted on the particular subject matter. And then in 4, second limb, there is determination of, quotes, the basis of reduction of future service benefits, which we say confers what I've said, a substantive discretion on the actuary as to the shape of alteration of benefit design to be adopted. Accrual rate, 1, 2, scale of salary linkage, 3, form of salary linkage, is it average salary rather than final salary? 4, reduction and increases to pensions in payment attributable to future service. 5, death benefits, etc., etc., etc. And then one's got in 4, so substantial discretion, we say, exercisable with all sorts of actuarial judgments there also. And then in 4, just to put the point to bed, interestingly, and it's not the best drafted provision, the first limit 4, but it says, as your lordships would have noticed, in the 3rd line tipping into the 4th, the benefits of members in respect of future service shall be reduced, calculated on such reasonable basis as may be agreed between the designated employer and the trustee, after considering actuarial advice. Why does it say calculated there rather than determined? Well, the answer is this. If there is an answer, the answer is this. In this case, the actuary is calculating that which has been agreed between the designated employer and the trustee. The designated employer and the trustee have agreed a particular and form of future service benefit reductions, and the calculated effect of that is what is being referred to. In fact, for the purposes of that calculation, as I submitted to you this morning in relation to our point 3, the fact that actuaries are doing calculations doesn't mean to say they're just taking a slide rule off the shelf and you know, as though it's anyone could do it. There's much more to it. But that, if there is an explanation for the use of calculated there rather than determined, we'd suggest that that's it. And then, thirdly, point 12, is Rule 21.1.3. And I will be looking at 21.1.1 with you as well. Rule 21.1.3, B13.219. This is, as we know, the case, addressing the case where there are no active members at the valuation date, and this is the provision which was only introduced in 2006. And if the question is asked, why was it put in at 3 between 2 and 4, I think insofar as anyone can guess at the answer, it is because it's dealing with contributions. And just as 2 was dealing with contributions, it's dealing with contributions. And that's probably why it went in there, rather than, as might be more helpful, if one had had foresight that this case was going to happen, putting it in after 4. In 3, there are 2 closely related examples of the use of the word determine and its cognates. Determination of the overall amount of participating employers' respective contributions, and then determination of the rate and period over which such increased contributions shall apply. And in both cases, the actuary is exercising professional judgment. In the first case, as to the amount of the increase of participating employers' contributions, this is not simply automatically the amount of the shortfall as mechanistically calculated. It does involve a determination rule, including, as appears from 3 itself, the allocation of contributions between participating employers. And as to the rate and period over which any such increased contributions are to be paid, there is a serious substantive judgment to be made, a series of them, as to higher or lower rates over a greater or lesser period chosen, front-end loaded, back-end loaded, or flat rate at discretion again. And there's no doubt, my lords, that in a Rule 21(1)(3) case, a participating employer would be wishing to argue for a possibility of the lowest possible contributions being spread over the most advantageous periods for them, and for the actuary's determination power importing the fullest discretion as to collection of employer contributions in that eventuality. Obviously, employer affordability would be a relevant consideration. It's a very subjective notion, but employer affordability would be a relevant consideration in this context. And we'd refer you, it's a well-known proposition, but for authority in that connection, I don't need to turn it up, the Court of Appeal in Edge and Pensions Ombudsman. It's at Bundle D1, tab 12138, and the reference by Lord Justice Chadwick is at page 628H, which is D1 12162. And further, in as a matter of judgment on the part of the actuary, he or she would need to take into account whether post-valuation events had caused the shortfall to reduce. And finally, Rule 21(1)(1), which doesn't apply any longer because it has its terms been satisfied. You see that the word determines is used twice there, and we would say that determines is being used again in a way which does involve judgments. It's judgments as to the value to be attributed to preserved benefits, which involve the consideration of precisely the kind of factors I was mentioning this morning, as to when people are assumed to leave service, as to their final pensionable salary at retirement, as to mortality, and whether the features of the particular cohort, it's the profile of the particular cohort entitled to the preserved benefits, suggests that you should adopt one mortality assumption rather than another, and so on, and so on, and so on. That's as to the numerator. And of course, as to the denominator, in order to get to the 2.5%, that's a determination of the Rule 21 shortfall generally. And of course, there's masses of judgments involved in that. And why again is the word calculate used in the first line? It's because you know that the parameters of which you're undertaking. You're being asked to establish whether x over y times 100 is 2.5%. Calculate whether x over y times 100 is 2.5%. But what is x and what is y is what you have to determine. And that's where judgment comes in. So let's just step back for a second at the end of submission 12. We're really interested, or at the end of the day, in the meaning of the word determines in connection with the establishment of contributions for the purposes of Rule 21(1)(2). And we know that the fourth meaning of the word determines in Rule 21(1)(2) involves establishing the rate and period over which they apply. The contributions are overlain with judgment and discretion as to affordability. And this is the echo, this is the resonance with the point that I made this morning about my learned friend's reference in relation to Rule 45(5) of the BRPS. He said that when it comes to deciding on the rate and payment of the additional contributions under Rule 45.5. Of course, you'd need to take into account the circumstances of the members. And we say, exactly, rate and payment in relation to the fourth time determines is used in Rule 21.1.2. You'd have to take into account the circumstances of the members. They are the gateway to Rule 21.1.2. The members' contributions are increased under Rule 3b, and therefore the employer's contributions are increased under Rule 3.5. You've got to take into account affordability, etc. in the fourth reference. Why on earth don't you take it into account in the second reference? We say, with respect, that you do. Point 13. We say it's really interesting that Article 7.5 of the Protection Order, which my learned friend has referred to you on a number of occasions, and it's at B11.146, it supplies a material point in relation to the construction of the actuary's powers of determination under Rule 21.1.2 and Rule 21.1.4 second limb. We introduced this point at paragraphs 52 to 55 of our skeleton, which I'm not asking you to turn up, it's just your note, at A10, 142 to 143. And one starts again with this submission, for which if we could have B11.146 open, I'd be grateful. B11.146. One starts again with the submission with the point that the protection order and the pension trust were brought into effect together, and it is plain, and we agree they should be construed alongside each other. There's no dispute between us on that, obviously. Now, Article 7.5, as you see, introduced an additional protection in relation to what might otherwise be done under Rule 21.1. That is, that even if the trustee and the designated employer are minded to increase contributions or to reduce benefits in relation to protected persons, even if they're minded to do it, not only does the trustee need to be satisfied that it could have been done under the BRPS, but, and this is the important bit, the actuary has to advise that such increase or reduction may or should be made. May or should be made. And then the point, as it bears on the construction of the actuary's powers under Rule 21, is this. Under the STEM, B13.218, the trustee, as we know, may agree with the designated employer an increase in contributions or a reduction in future service benefits. And under the first limb of 21.1.4, the trustee may agree that a reduction of future service benefits should be made. Article 7.5 says no such agreement can be made in relation to protected persons unless the actuary advises that it may or should be made. Article 7.5 does not say that no such agreement can be made without taking actuarial advice, which, rather consistently with their general downplaying of Article 7, is how the appellant's option A argument would have had it. Article 7.5 does not say no such agreement can be made without taking actuarial advice. Article 7.5 is, in its own words, conferring a substantive role on the actuary, exercisable in his professional judgment as to what may or should be done. And it is a role applicable to the provisions of Rule 21, empowering the trustee to do certain things. As a result of Article 7.5, unless the actuary advises that increases in contributions or a reduction in future service benefits may or should be made, it can't be made. It simply can't be made. Now, the appellants argue at paragraph 58.2 of their skeleton, A9119, that the actuary's role under Article 7.5 is a kind of public trustee and Cooper category 2 role, if I can go into chancery speak.
Well, if this is going to be important, I'm afraid you'll have to explain it to me. But
I asked,
sure
I asked for that.
Yes.
What they suggest is that the actuary's role is its sole role is to arbitrate between relevant considerations. Sorry, forgive me. To arbitrate, scrub that. They argue that the actuary's sole role is to arbitrate whether relevant considerations have been properly taken into account by the trustee. They seek to temper what they say at paragraph 58.2 by the addition of the words actuarially speaking. But this is based on a rewriting of Article 7.5. It's not just by reference to actuarial calculation. Article 7.5 does not say that no such agreement can be made without taking actuarial advice. It says no such agreement can be made unless the actuary advises it may or should be made. But the real point here is that the appellant's argument on paragraph 58.2 of their skeleton actually undermines their case. Because if the point they're making is it's the actuary's job under Article 7.5 to arbitrate whether relevant considerations have properly been taken into account by the trustee. The reason it undermines their case is as follows. Collectability, based on affordability and value for money, are, as the Chancellor rightly held in paragraph 94 of his judgment, A240, collectability based on affordability and value for money, they are plainly relevant considerations for the trustee in the exercise of its powers under the stem and for. And similarly, therefore, on the appellant's own case, collectability must be a relevant consideration for the actuary when it comes to the performance by him of the arbitral role which, according to them in paragraph 58.2, is conferred on him. So it not only doesn't carry their case forward to say what they've said in paragraph 58.2, it actually torpedoes their case. Because if the actuary is there to arbitrate as to whether relevant considerations have been taken into account, much as a court might, in deciding whether to approve in a blessing application, whether trustees have properly exercised their discretion or not. If affordability is a relevant consideration for the trustee, which plainly it is, then if the actuary's role is to arbitrate on relevant considerations, his role under Article 7.5 is also to arbitrate on collectability. And the fact is that the role under Article 7.5 is the role to say, in relation to what the trustee is proposing relevantly to do, whether it may or should be done. Now, the submission then develops as follows, positively on the part of the trustee. Collectability, affordability, and value for money plainly being relevant considerations in relation to the operation of the trustee's powers to agree under the stem and for, over which the actuary has an Article 7.5 oversight role, it makes no sense to contend, as do the appellants, that the actuary, under the in default of agreement provisions of 2 and 4 second limb, does not have a like discretion to bring into account collectability, duty to bring into account collectability, in relation to his own independent powers to determine an increase of contributions or a reduction of benefits. If it's right, as it seems plainly to be, we would say, that Article 7.5 is in relation to trustees' powers, which plainly involve proper consideration of collectability, affordability, value for money factors. If it's right that the actuary under Article 7.5 in relation to protected persons is being given a role to say whether something may or should happen, he's naturally to be regarded as relevantly taking those considerations into account himself. And if that is the case, that's the first stage of the argument. And the second stage of the argument is, if that is the case in relation to his supervision of the trustee under the stem and the first limb of 4, then it makes no sense to say that he throws off any consideration for collectability, affordability, value for money, when he comes in default of agreement under the stem, or in default of agreement under the first limb, to consider the exercise of powers himself. It just doesn't make sense. Now, to complete the submission in relation to this, whilst Article 7.5, with its reference to the actuary advising as to what may or should occur in relation to contributions increases and future service benefit reductions, only applies in relation to protected persons, whereas the actuary's determination powers under Rule 21 apply both to protected persons and non-protected persons. Determination cannot mean different things in each case. It's a single determination power under 2 and under the second limb of 4. And so the force of the submission is, quite apart from the fact that pretty well everyone was a protected person from the get-go, and half the membership still are protected persons. Put that to one side. The submission is, this line of reasoning, if your lordship's with us on it, clearly suggests the existence of the propriety of the taking into account of collectability in relation to the trustee's powers, therefore similarly in relation to your own powers, and it's a single power with a single construction. Point 14. Point 14 I hope I can take reasonably quickly, because I don't really think at the end of the day that there's a huge amount of dispute between us. It's a point which is made in my learned friend's skeleton, that is paragraph 68. It's but he didn't seem to develop it on his feet, and it's this. It's a point which you see in paragraph 68 of their skeleton, which is A9121, and it's the same point as you would see in Appendix 2 of their first instance manual at paragraphs 30 and 31 at B20 277 to 278. And the point is introduced, and it pivots.
You haven't told us what the point is yet, Mr. Green.
Yes.
It's very difficult to take this down. I know it'll appear on the transcript, but you're saying you haven't told us what point 14 is yet.
No.
Why don't you tell us what point 14 is before you give us all the references?
The intro to the point is this, that the appellants contend that in the first limb of Rule 2114, the powers conferred on the designated employer and the trustee to agree whether a reduction in future service benefits may take place. And the actual words, as we've seen, are shall be reduced, page 219, shall be reduced calculated on such reasonable basis as may be agreed between the designated employer and the trustee. The contention on the part of the appellants is that that is a discretionary trust, which prior to the introduction of the second limb, but logically also after the introduction of the second limb, but which, let's just take it at its face value at the moment, prior to the introduction of the second limb would have been executed by the court in the absence of agreement, on the basis that this is the shortfall shall be made good submission. And because the designated employer and the trustee are being told the shortfall shall be made good, then they're obliged to make it good, they're obliged to make it good in full, and if they don't agree to do so, the court would force them to do so, and indeed would substitute its own view, impose its own view, in order to extinguish future service benefits in total if the future service benefits were less than the shortfall or equal to it, or would substitute a view to the extent that future service benefits were less than the shortfall, but at least to ensure that future service benefits were extinguished in their entirety. So the submission on, in paragraph 68 of the appellant skeleton, and it's the same point, as I say, I apologise for causing confusion earlier, it's the same point as appears in their first instance manual at paragraphs 30 and 31 at B20 277 to 278. The notion is that the mandatory nature of the extinction and elimination of the shortfall pursuant to the operation of these provisions is reflected in the fact that the designated employer and the trustee are, as regards the roles conferred on them under the first limb of 4, to be regarded as co-discretionary trustees. Well, my lords, that proposition in our respectful submission merely needs to be stated to be seen to be wrong. It's undoubtedly the case that a trustee, if it's got a duty to do something and doesn't do it, this court can not merely tell it to do it, but in appropriate circumstances either remove it or actually do it if it's appropriate, to leave the trustee in office. There's no doubt about that. And there's no doubt that that proposition applies if there's 2 trustees in office, just as much as if it applies if there's 1 trustee in office. But the problem for the submission is that there aren't 2 trustees in office. This is 1 trustee who will be entering into, who's empowered to enter into an agreement, if it thinks fit, with a person, a designated employer, acting in an entirely separate capacity, effectively a beneficial capacity constrained by the imperial duty of good faith. It doesn't even have a fiduciary power, let alone is it a co-trustee to whom directions of the court could be given to actually exercise the power in a particular way. And this submission then is used as a kind of launch pad for the suggestion that, well, because the designated employer and the trustee are discretionary trustees in relation to the power in the first limb, and that the court would forcibly have executed the power in circumstances where there'd been a failure to do so, where the proposition would have to be the designated employer and the trustee, in dereliction of their duty to agree, had forced to do so. The proposition then is that that has a trickle-down effect into the second limb of 2, and that the actuary correspondingly is under an immutable duty to extinguish future service benefits in full if the future service benefits are less than or equal to the value of the remaining shortfall after the operation of 2. And we say that that's a wholly impossible proposition. It interestingly, actually, my lord, Sir Launcelot, it interestingly feeds back into your remarks to me right at the beginning after the short adjournment, doesn't it? Because if the actuary is a fiduciary, then you can see how the submission bad as we respectfully say it is, might begin to have one leg. But if the actuary is not even a fiduciary, where then? But in any event, so that's the way the submission develops. And then the way it develops, and it's very curious this, but I feel I need to pick it off. The way it then develops briefly in the skeleton, but in the manual is this. What you're told is, and the manual, the paragraphs in question, lumps the trustee and designated employer agreement provision under the first limb together with the actuary determination provision under the second limb, and the manual then says, and the way it all works is this, whether you're looking at the first limb or the second limb. If the shortfall remaining after the operation of Rule 21.1.2 exceeds or is equal to the value of the future service benefits, they have to be eliminated in full. That's the submission. That's what these words are saying. But it says, what these words convey, if the shortfall remaining after Rule 21.1.2 is less than the value of the future service benefits, then there is a substantial discretion in the designated employer and the trustee as to which future service benefits should be reduced. And similarly, there is a substantial discretion in the actuary in that case as to which future service benefits should be reduced. And the manual says, although the word reasonable is used only in the first limb, clearly that reasonableness also should apply to the second limb in that eventuality. That's what they say, and obviously, as a matter of logic, that must follow. But the answer to it is that we're dealing with, there's no suggestion at all in the wording of 4 that this distinction exists. There's no suggestion in the wording of 4 that powers are being conferred involving a duty to exhaustively extinguish future service benefits in one case, but only, but then a discretion as to which are to go in another. These are single powers, and they're to be construed in a singular way. And the suggestion that 4, and the whole lead-in to the submission, I mean, it's taken me a little time to attempt to decode it. The whole lead-in to this submission is the proposition that the first limb involves a discretionary trust, and so there's an obligation to fully, to exercise it, which the court will enforce, and which will extinguish future service benefits if the shortfall is greater than or equal to them. That's the way in.
Or more simply, it might hang on the word shall.
Indeed, which I addressed your ladyship with this morning. Yes. Yes. But again, my lady, on the word shall, it's still, we'd say, it's a single power. It's not a power which is drawing a distinction, of the kind we're describing. Now, I don't think I need to weary you with the imperial duty. I think, sorry, forgive me. Two presumptions in that sentence. You'll be a further presumption coming up, familiar. No, well, as your lordships be aware, the imperial duty of good faith, which originates in the pensions context, determinatively in the pensions context, with the decision of the Vice Chancellor, Brown Wilkinson, in the Imperial Tobacco case in 1991, is the case which confirmed that when, certainly in the ordinary course, if an employer has a power under a pension scheme, it's going to be subject to the imperial duty, not to exercise it in a way which seriously undermines the trust and confidence inherent in the employer-employee relationship. And that's now recognised, as was recognised in the Dalgleish case, which we've referred you to, as being in the nature of a constraint on the exercise of what is otherwise effectively a beneficial power. That's Dalgleish paragraphs 28 to 29 at D320 to 630. And that reference, I think, in the preceding paragraph states the imperial duty. But for your note, the passage in imperial where the duty is described is in the authority at D11095. And in excuse me, in the IBM case, the Court of Appeal went on to note at paragraph 33, that's D320632, that the constraint in question does not of itself render that which is a beneficial power fiduciary. And further, it said that although the imperial constraint may mean that the employer subject to it is subject to an irrationality or perversity test as regards the exercise of its powers, the court does not, in relation to an employer subject to the imperial constraint, substitute its own decision for the decision of the employer as the relevant decision maker. And that's IBM at paragraph 45, D320, 635. And so what's happened in this area of the law is that there was a willingness, or in the context of the particular facts of its case, which was one of liquidation, insolvency. In the Metoy case, which my learned friends have put into the bundle, Mr. Justice Pierre Warner had suggested that an employer's power, the surplus, was fiduciary, because and it may indeed have been in that case, but because of the particular context. But what subsequently developed as a result of imperial tobacco, Metoy was about 1989, what subsequently developed as a result of imperial tobacco was a recognition that employers' duties are not generally to be characterised as fiduciary in a pension context, but subject to the constraint of not being exercised so as to seriously undermine the relationship of trust and confidence. And it's that duty which is authoritatively restated in IBM and Dalgleish, and stated in terms of it being a constraint on what is generally a beneficial power. So, and that's, if you like, the prism through which a lot of the discussion which my learned friend has had with the court is to be looked at. 130% cap being subject to the imperial constraint, and any agreement power of the designated employer under the STEM or under 4 is subject to the imperial duty. But none of that makes the employer a co-trustee, evidently. No more under the first limb of 4 is the employer a co-trustee. Is the employer a co-trustee under the STEM? And the fact that the STEM has got the power of the designated employer and the trustee to agree things, nor does it make the principal employer a co-trustee where, in the thousands of other examples you have in pensions cases, of powers to amendment being conferred on a trustee with employer consent or an employer with trustee consent, nor in those cases does it make the employer a trustee. I mean, there's no doubt that an employer can be a trustee, but you'd require very particular language to get to that, and it's plain that the agreement provisions here are not that.
And that would surely be very unusual in a pension context. I imagine it can, in theory, happen. Perhaps you have far more experience than I would ever have had, but on the whole, one thinks of the good running of pension schemes is going to be promoted by keeping the roles separate.
Well, so, look, post-good, it's being
and no doubt it's now, now mandatory anyway.
Yeah, exactly. And post-Maxwell, it's become absolutely mandatory.
Quite.
Pre-Maxwell, they may have been behind the corporate veil.
Yes.
Coincidence of management and control, but all of that is now heavily
Well, that
regulated.
takes one, yes. Okay.
But I'm not sure. I could ask what the revenue requirements were for establishing.
Yeah, sorry, so
schemes.
no need to go any further into that, but thank you.
Oh yes, as my own friend. No, that's absolutely right. As my own friend rightly says to me, you still have employer representatives, trustees,
Oh, yes.
and on a corporate trustee you'd have employer directors
Yep.
and nominated directors and member nominated directors.
Thank you.
That's absolutely right, of course. But yeah, but the elementary point that I was making, that clearly the employer can be a trustee, just ain't. It stands. Point 15. Pensions actuaries, the qualifications of a pensions actuary to carry out the determination role that I've been describing. And the proposition here is that an interpretation of scheme rules which recognises the ability of the actuary to exercise judgment as to matters of fairness and reasonableness, including as to the circumstances of contributors, and by contributors I include employers, an interpretation of scheme rules which recognises the ability of the actuary to exercise judgment as to matters of fairness and reasonableness, including as to the circumstances of contributors, is foursquare within what is recognised to be the competence of a pensions actuary. Specialist pensions actuaries are steeped in the matters in respect of which determination, powers and duties are conferred under Rule 21. And the professional experience and expertise that such an actuary brings to bear to his role is amply capable of embracing the making of judgments as to the fairness and reasonableness of a course whose determination is entrusted to him under the rules. A point specifically stated to be so in the decision of the very experienced pensions judge, Mr. Justice Lloyd, as he then was, in the Airways Pension Scheme case. Now, that case is at D2-15268, and if you would just be a little patient with me, if we could just look at it, because although the statements of principle are shortly made at paragraphs 41 and 56, and that's really my landing point, D2-268. Nevertheless, to get to the landing point in relation to what Mr. Justice Lloyd said, it's quite interesting to see what the domain within which the discussion was occurring consisted of. So if you wouldn't mind, please, starting with paragraph 13 on page 272. And the context is, in this case, that at this stage in the life of the Airways pension scheme, there was a surplus. And there was a dispute as to how the surplus was to be allocated. And British Airways was keen that it shouldn't be, as it were, used up, but rather should be retained so far as possible for future days. And they employed a counsel named Mr. Green, who had almost all of his submissions rejected in order to try to advance that case. And you'll see that as we go through.
I don't think I've ever seen a case where the summary, by way of comment, says the case turned on its own facts. But
Yeah, well,
no specific points of law appear to arise. All right, go on. It's one of your war stories. So tell us.
I think, my Lord, I think you'll see that despite the comments of the learned and opinionated commentator who edited the pension law reports at this time in its history, a great man, I have to say, Possibly Mr. Justice Lloyd's views hold more weight. I just mentioned that.
Okay, paragraph 13.
So, yes, paragraph 13.
Yes.
Yeah, yes, so clause 11, this is the duties of the actuary, and this is to conduct valuations. And at little a, he shall make a valuation. And then little b, in conjunction with each valuation made in accordance with a, you'll see, if the actuary certifies that a deficiency or disposable surplus, as the case may be, is attributable to an employer, in this case it was British Airways, he shall certify the amount thereof, and the management trustees shall, within 3 months after receiving such certificate, make a scheme for making good the deficiency, or, as the case may be, or, as the case may require, disposing of the disposable surplus, provided that any such scheme shall be subject to the agreement of the employer to which it applies, or, and here's the meat of it, in default of agreement shall be referred to an actuary to be appointed in default of agreement by the Institute, and shall come into force subject to such amendments, if any, as the actuary may direct. So,
that seems to be referring the issue to, in effect, an actuary as an arbitrator.
yes, indeed, but recognition of his expertise. Yes. Yeah. Then little c deals with deficiency, and then little d, if the actuary certifies that there's a disposable surplus, then attributable to an employer, the scheme referred to in B shall provide for certain things. In other words, it will have certain characteristics. And as you'll see, the counsel for BA was suggesting that it had to have only those characteristics and that they were extremely restrictive. So we then move on to paragraph 21, which says that the minister had a role originally under clause 11b as a tie-break. We'll come back to that. I'll only refer you to it because it figures. Paragraph 23, if there is a surplus rather than a deficiency, the actuary has to consider whether or not he can certify that there is a disposable surplus, and if so, what is its amount. One of the matters debated before me is the meaning of disposable surplus. It's at least common ground, and clearly correct, it's not the same as surplus. It doesn't follow from the fact that the actuary's calculations show a past service surplus of assets or liabilities of a given amount, that this amount is a disposable surplus. Actuary has to exercise professional judgment in deciding whether any, and if so, how much of a surplus is a disposable surplus. Trivial, prudent, that sort of concept. Counsel used the phrase raw surplus to refer to the bare result of his actuarial calculations before he considers how much, if any, is disposable. And I'll adopt that. One of the issues is whether a disposable surplus is necessarily limited, not only at the threshold by whatever reserve the actuary decides to fix, so that's the reserve in order to get to the surplus in the first place, but also by way of a ceiling to whatever amount can in fact be applied in accordance with the provisions of 11D1 and 2. If the disposable surplus is more than enough for these purposes, there could be a balance of disposable surplus left. On one submission, however, that balance is not disposable surplus at all. British Airways trying to say the balance is not disposable. It is therefore convenient to adopt another phrase for that balance, which does not beg the question whether it is disposable surplus, and I will use residual surplus for that amount. So we've got the raw surplus, the disposable surplus, and anything after D1 and D2, residual surplus. 24, we only need the first sentence of this. If there is a disposable surplus, it is required to be dealt with by a scheme under clause 11b for disposing of the disposable surplus, and that scheme must make the provision laid down in D1 and 2. Paragraph 28.
28.
28, please, page 277. It's only the first few sentences. What's the meaning of disposable surplus? As I've said, it's agreed and clear that disposable surplus is not the same as raw surplus. Once the actuary has made his first calculations on the triennial valuation, which show a surplus rather than a deficiency, he must consider whether there is a disposable surplus, and if so, how much it is. In performing that task, he may make an allowance by way of reserve, whether against general contingencies or, I dare say, against more specific factors, so as to reduce the amount available to be considered a disposable surplus. He can do this even if he has also built in an element of reserve at the first stage of his calculation, and the actuary, Greg Alexander, did so. Paragraph 36. I don't accept Mr. Green's first submission that disposable surplus cannot include residual surplus. The actuary must consider the amount of the raw surplus and should make what allowances he thinks proper in the interests of prudence, judgment, by way of preserving any part of the raw surplus which he regards as not to be disposed of. Once he's done that, bearing in mind the various factors already discussed, he's left with an amount which he does regard as disposable. Paragraph 40. Paragraph 40, page 281. Then I come to the next point. Just need the first two sentences of this. Then I come to the next point. On the footing that disposable surplus includes any residual surplus, does the scheme made under B have to deal with the whole of the disposable surplus, or may or must it be limited, as Mr. Green submits, to that which falls to be dealt with under D? 41. In my judgment, the correct reading of clause 11 is that a scheme under paragraph B may, but is not required to, dispose of the whole of the disposable surplus. Okay? It doesn't say dispose of the disposable surplus in full. Slight resonation. Is not required to dispose of the whole of the disposable surplus. And the scope of the provision which may be made as regards residual surplus is not limited to what may be done under other clauses of the scheme. One of Mr. Green's submissions for limiting paragraph B, blah, blah, blah. Conversely, Mr. Inglis-Jones and Mr. Oh, sorry, forgive me. This is important. So it was blah, blah, but it was important. One of Mr. Green's submissions for limiting a paragraph B scheme to what is provided for under D and E is that it is only matters of that kind which can sensibly be submitted to an actuary for determination in default of agreement. Conversely, Mr. Inglis-Jones and Mr. Simmons submitted that if it was so limited, there would be almost nothing for an actuary to adjudicate on. There would be so limited scope for disagreement. And Mr. Justice Lloyd says he was referred to, and it's not in your bundle, but it's a brief statement. I was referred to the observations of Mr. Justice Robert Walker in National Grid about the range of tasks that might reasonably be expected to be performed by actuaries at paragraph 95 of the judgment. And that's where Robert Walker said, in that case, that I think actuaries have got immense capacity to deal with all sorts of issues, but counsel persuaded him from deciding the case on that particular basis. But if your lordships would like to look it up, sorry we haven't provided it, but there's the reference. Then Mr. Justice Lloyd says, well, when the arbiter was the minister, it couldn't sensibly be said that the scope of the power of determination was limited to D or E. And then here comes the punchline. The words of paragraph B cannot readily be understood as having changed their meaning with the substitution of a different arbiter. And then, moreover, I do not accept that an actuary experienced in pension scheme matters would not be a suitable arbiter. It may be that another professional might have been used, but an actuary who could be the scheme actuary could, in my judgment, be expected to be capable of deciding fairly between the rival contentions, even if the scope of the matters the subject of disagreement is wide. And then paragraph 56, on page 285, there was some debate before me about the scope of the role of the appointed actuary, but in the end I don't think there was anything much between the parties as to this. Once the question is decided as to what is the scope of a paragraph B scheme over which he has authority, I realise that the conclusion to which I have come, that although there is a duty to make a paragraph B scheme, it does not have to dispose of the entire disposable surplus, means that there is more rather than less scope for disagreement between the trustees and the employer, and therefore the area over which the actuary has to adjudicate is the more extensive. It seems to me clear that the actuary has to consider the proposals by the trustees and those put forward by the employer, and either side's objections to the other's proposals, and has to ensure that he is properly informed as to the circumstances of the scheme, and must then decide whether, and if so how, the trustees' proposed scheme ought to be modified, so as to be the appropriate scheme to be put into effect in the circumstances, being fair and reasonable, having regard to the interests of all concerned, members, pensioners, others, such as dependents, as well as the employer. Now, as you'll have seen from paragraph 13 of the judgment, the role given to the actuary appointed in this case is significantly more extensive than the role under the second use of the expression determine in Rule 21.1.2. And yet, Mr. Justice Lloyd didn't have the slightest difficulty in holding that it was well within the competence of the pensions actuary to essentially decide the fate of surplus and in its entirety, and whether with the assistance of the trustees or off his own bat he could go to court in order to get assistance in relation to that didn't need to be gone into. But this is at least as onerous a task as Rule 21.1.2, and that's what Mr. Justice Lloyd had to say about it. We then put in, so he said that the actuary's role as to whether to approve, with or without amendment, a scheme to deal with the disposable surplus as being to achieve a fair and reasonable result, having regard to the interest of all concerned. It can hardly be suggested that Mr. Justice Lloyd would have envisaged that the actuary should have been doing anything different in addressing a scheme to repair a deficiency. That's our submission. Now, you've also got in your bundle a venerable authority on what actuaries can and can't, or can be expected to be capable of doing, in the form of the Re George Nunes case, which is D1723.
It's quite an old case.
So it's D1723.
We're still on point 15.
Oh, we are.
Actuaries are well qualified to decide.
Yes, because these are the authorities which underpin what Lady Justice Asplin observed yesterday, as to it's no mystery to the judiciary that actuaries have got these extremely wide potential powers open to them within the armoury of their professional competence. And D1723 is the Nunes case. We only need paragraphs 20 and 21. And of paragraph 21, really, we only really need that which appears on page 30.
I'm sorry, who is the judge here?
Mr. Justice Buckley. So it's a case which dates from 1969, although it only was widely reported. It got into the Faculty of Institute of Actuaries reports some years after it was decided. But it was only widely reported in 2007, and that's the report which you have here. So if you just looking at 20 and 21 the function of an actuary in advising how a pension scheme should be dealt with on the determination of the scheme, perhaps the context on determination, is to achieve the greatest practicable degree of fairness between various persons interested in the scheme consistent with the rules governing that scheme. He cannot ignore or contravene those rules, evidently, and in the pursuit of fairness, he may also have to pay regard to the spirit of those rules in respects which are not controlled by their express terms or necessary implication. But, consistently with the rules, he must do his best to achieve as fair a distribution of benefits as the size of the available fund, the character of the scheme, and the circumstances of the contributors make possible. Circumstances of the contributors, that's the origin of the phrase I used to describe the point. In 21, in performing this function, an actuary must employ an expertise of great refinement, which involves assessing the weight to be given to many and various contingencies and near imponderables. Some of these, such as mortality tables, may depend on statistical data and may be susceptible to more or less demonstrable validation. Though obviously they'll still be the subject of choices having regard to the demographic. Others, this is the more important point, must necessarily be largely a matter of personal judgment. Recognition, even in these early days, many things that actuaries do in the routine of pension scheme advice involves matters of personal judgment, where there's maybe considerable scope for justifiable differences of approach and opinion. The actuary's function is essentially one of estimation. One may very possibly reach a conclusion which varies from another. So that's George Newnes. So in George Newnes, we get from that at 20, Mr. Justice Buckley was referring to actuaries exercising powers vested in them to achieve the greatest degree of practical fairness. And we noted the explicit linkage at the end of the passage to the circumstances of the contributors. And that at 21, he recognised that it was an expertise of great refinement and that it involves assessing the weight of many and various contingencies and near imponderables, many of which, some of which must necessarily be largely a matter of personal judgment. His statement was made in relation to the actuary acting consistently with the rules, and we say, well, obviously so. The actuary has to act in accordance with the scope of the power conferred on a true construction of the rule which empowers him. And it's the trustee's case that bringing to bear consideration of the implications for collectability of setting unaffordable contribution rates or eliminating future service benefits altogether, and hence of whether and to what extent what is proposed will actually make good the shortfall, is doing just that. Our case is that bringing to bear those considerations is doing just that for the purposes of the rule as properly construed. The George Newnes reference was approved by Mr. Justice Walton in the the case of Imperial Foods. It's at D1834. I won't need to turn it up. It's a short passage at page 729 F to G, which is D1846. So just my final remark in relation to this point, the appellants contend, or contended in the High Court, the appellants contended in the High Court that the actuary is precluded from the exercise of judgment as to matters of fairness and reasonableness, including as to the circumstances of contributors here, because that is not consistent with the rules. But they don't establish how and why it is that on a true construction of the rules, that practical fairness and consideration of the circumstances of the contributors is to be excluded. And as we've endeavoured through our submissions to make clear, such a preclusion is not justified by reference to an appeal to what is required to make a shortfall. Lord, would that be a convenient moment?
Yes, it would. Right. We resume at 3:25, and will that be point 16?
Yes.
Good. 3 to go.
told you.
No, that's right. Yes, if it's been just
So I might be arrested for the website.
Right. Indeed, well, that was the agreed process in the exchange of emails last night. It was going to be agreed this evening, so we're just yes, one of the things do you want, I mean, you don't need to have that much. We can get yeah. Yeah.
Well, that's I did get some feedback. Yes. I'm not going to tell you what it is though.
Oh dear. Right. So he's been Oh, I think it was still.
Edwards told me he was very keen to still.
Well, yeah, well, you're right.
Yes.
Anyway, it's not maybe not stable. Then it,
Is everyone ready to reconvene?
I'm ready, but I don't have much to do. Pleasure
Yes,
of
we're ready,
listening.
please.
that's the plan.
Lord.
Yes.
Thank
Point
you.
16.
Point 16, reasonable and practical effect. Yeah. The in pensions context it's pensions context speak for commercial and business sense. So our submission here is that not only is the trustees reading a textually coherent reading of the act.
I'm sorry, could you lift your voice a little bit for me? Sorry, I think I've got some traffic noise as well.
Thank you, my lady. Our submission here is not only is the trustees reading a textually coherent reading of the actuary's powers of determination under 2 and 4, it is a commercially coherent reading of such powers, or, to use the expression commonly adopted in relation to pension schemes, it is a reading to be preferred for its giving reasonable and practical effect to the scheme. That was the formulation of Mr. Justice Millett in Courage at page 505, as quoted in various of the authorities before you. Courage isn't. And it is that formulation, reasonable and practical effect to the scheme, wherever possible, so as to give reasonable and practical effect to the scheme, that formulation was approved by the Supreme
Court in Barnard. Yes.
Yeah, there we are. It was approved by the Supreme Court in Barnardo's at D4 22725 at paragraph 16, and that's D4 22731. I wasn't proposing to take you to Barnardo's, but I think you're familiar with it. But that was the formulation approved by Lord Hodge and the other members of the court in Barnardo's, and acknowledged by Lord Justice Nugent as the sense in which commercial and business sense tends to be understood in the pensions context. In his decision in Britvic, his judgment in Britvic, Britvic is at D4 23735, and Lord Justice Nugent's recognition that reasonable and practical effect to the scheme is the counterpart to commercial business sense is at paragraph 72, letter D, D4 23755. Yes, of course, as Lord Justice Nugent emphasised, Mr. Justice Millett had said in Courage that reasonable and practical effect should be given to the scheme, quotes, wherever possible. Of course, we recognise that, but in our respectful submission, it is certainly possible to do so here, and our submission does that. This is not, with all due respect to the appellant's skeleton, this is not, as we have already hopefully made clear, a case of the trustee seeking to rewrite the words on the page to produce a more literate scheme. It's a case of the trustee taking the words on the page and saying that the trustee's construction does accord with their natural meaning, and that at the end of the day, the appellant's case is all about those words at the end of the stem shall be made good in the following way. And at the end of the day, those words do not, as a matter of literal construction, carry the connotation of made good in full. That is the position. But if you think that there is scope for debate on the question of construction, then clearly one gets into reasonable and practical effect, commercial and business sense, and on that we suggest that a proposition that says that you shall take account of collectability for the purposes of making good the shortfall makes reasonable and practical sense in a way which, not taking account of collectability and bringing about complete opt-out with no contributions being collected at all, simply does not. Our construction case, as you know, is based on the meaning of the word determine and cognates, not based on reasonable and practical, but based on what they are saying on the page. It's based on the meaning of the word contributions, what contributions actually means, not reasonable and practical interpretation of what a contribution is, but what a contribution is. And it's based on shall be made good as follows, having a clear meaning once you actually understand what the limits of what was contained in 2 and 3, and with the limits of what continues to be contained in 2 and 4, as not being the same as shall be made good in 4. But as we say, if you are going to go to reasonable and practical solutions, if you are going to look at commercial and business sense, as a tie-break, the trustee's interpretation is to be preferred. Now, you've got all the authorities in before you, more than you need. You've got Bernardo's. My learned friends put in Arnold and Britain, so we countered by putting in Rainy Sky and Wooden Capita, and it's not really going to help you in the slightest, because at the end of the day, Bernardo's says it all, and in any event, with the greatest respect, you know it. So I'm not taking you to any of that. As you'll have seen from our skeleton argument, we observed that on the commercial and business sense test, on the reasonable and practical effect test, our interpretation is to be preferred, and that, frankly, the appellant's interpretation is, quotes, divorced from reality. And we picked up, as we said in our skeleton, that expression, divorced from reality, actually from Mr. Justice Warren's observations in the pilot's case, which I recall sitting alongside Lady Justice Asplin at the hearing of, in the pilot's case, where Mr. Justice Warren, in a context akin to this, said of the suggestion that the pensions regulator would, against a backdrop of a shared cost scheme under which employers were obliged to pay 1.5 times the contributions of their employees, the notion that the pensions regulator would be obliged to impose a contributions liability based on shared costs which would drive the employees out of the scheme was divorced from reality. And it's not the same as the present case, but there is
Do we
an
have that in the
interesting
bundle?
resonance.
Mr. Green, do we have that in the bundle?
Yes, you do. And
Yes.
you,
Just give us the reference.
I will. We refer to it at paragraph 57 of our skeleton at A10-143. And the divorced from reality, the imprimatur, judicial imprimatur to divorced from reality in this context, or in analogous context, PNPF v Taylor, D116-290 at 397 to 398, and it's paragraph 685. The intro to Mr. Justice Warren's statement is the discussion at 682 to 683.
Thank you.
So if your lordships are interested in following through the point, it's 682 to 683, and the conclusion is at 685. Indeed, we would suggest that the unreality of the appellant's case is actually recognised by the appellants themselves. They simply shrug their shoulders and say, well, active members can and will opt out. And we say that the court is entitled to ask itself in relation to the appellant's case, applying a reasonable and practical interpretation test, whether that is what Rule 21 is there for. We suggest it is there to provide a machinery, so far as practicable, for injecting life into the section, not a machinery for stifling its continuing operation. And the fact is, as you will have picked up from our skeleton, from the way in which the Chancellor faithfully reflected our submissions before him, the truth is that the appellant's construction of Rule 21.1.2 involves no more than a token arithmetic exercise. The first fall of the appellant's so-called waterfall produces a contributions figure avowedly to make good the shortfall. The second fall of the so-called waterfall ensures that the contribution will never be collected, since following 100% opt-out, no employer contributions under Rule 3A will be receivable at all. That's the 1.5 times 0 equals 0 submission. And contrast the trustee's approach, under which the overall outcome of the operation of 2 and 4 will ensure the practical operation of both sub-paragraphs, the collection of contributions under 2, notwithstanding potentially a reduction of future service benefits. And I'll return to this when we address the question of when Article 7.1 cuts in. Point 17. Rule 45.5 of the BRPS is not relevant and doesn't assist the appellants in any event. Now, it's not really clear to me to what extent the appellants are really running with the notion that Rule 45.5 exerts some substantial influence on the construction of Rule 21. But there should be no doubt about it, that it doesn't, it can't, and it doesn't. There is no doubt that the drafters of the RPS and the government and unions who negotiated the RPS's provisions had the rules of the BRPS in front of them. There's no doubt about that. But there's equally no doubt that in multiple respects they used different language, and it is that different language as contained in the RPS that falls to be construed, not the language contained in the BRPS, which was wound up in 1994. The RPS owed its existence and its language entirely to Articles 2 and 3 of the RPS order, B424. the RPS owed its existence and its language entirely to the RPS order, Articles 2 and 3 at B424. And those articles took their authority from Schedule 11, paragraph 2.1 and 3 of the Railways Act 1993 at B10109. And the provisions of the RPS, the Pensions Trust and the rules, were set out verbatim in the schedule to the RPS order. Now you only have extracts of that schedule before you in the bundle at B4. But the provisions of the RPS and the rules of the 1994 pensioners sections, the shared cost arrangements and the other arrangements provided for, run to hundreds and hundreds of pages. And the RPS was from the outset a freestanding creature of statute. It was a new beginning for the privatised railways industry to operate under and in relation to. It did not owe its existence to anything that was done under the provisions of the BRPS or to the provisions of the BRPS. Indeed, the transfers into the RPS were not effected under provisions of the BRPS, but by a further and separate statutory instrument, as you've been referred to, the Transfer and Miscellaneous Provisions Order, B666. That order transferred the members, the assets and liabilities across to the RPS from the BRPS without any intervention or requirement for exercise of any powers under the BRPS. And that instrument, by its Article 211 at B667, then wound up the BRPS. The RPS was a fresh start, and the construction of its provisions is a fresh construction exercise. So we've said that the drafters of the RPS use different language contained in the BRPS in multiple respects. And you'll see specifically when you come to the issues in this case that Rule 45 of the BRPS, which is at B2, 14 to 17, and Rules 20 to 21 of the RPS at B4, 50 to 51, were plainly not the same provisions. One merely has to look at them as originally drafted. They present as differently drafted provisions. And to suggest, as the appellants now only seemingly faintly do, to suggest that because Rule 45.5 provided for X, therefore Rule 21 of the RPS should be interpreted as providing for X, is plainly fallacious. The differences are apparent from the respective provisions from their very first lines. If you just look at B2.14, Rule 45, B2.14, the computation of the shortfall was even different under the BRPS. If you look at the third sentence of 45.1, the report shall state whether the assets of the scheme, together with expected future income, are likely to be sufficient. It was a past service calculation. It does not include future contributions. And as is common ground, the reference to future income is future investment returns. And the actuary confirmed this, insofar as there is any doubt about it, at B15233, paragraph 3.1, little c, little Roman numeral 3, and footnote 3. The scheme actuary explained that the reference to future income where it appears in the RPS is to future investment returns. Rule 20 and Rule 21 bring in future contributions. So even from the very beginning, it was a different provision. You then just carry on. They deal very differently with preserved benefits. Rule 45.4 at B2 14 to 15 placed the whole of such liability on the principal employer at every shortfall valuation. Rule 21.1, as we've seen, B450, only did so if such liabilities exceeded 2.5% of the prospective benefits shortfall, and did so only on a once-only calculated basis. So if at any point preserved benefits were less than 2.5%, little one fell out of contention. No comparison with 4. So 45.4, continuous application without any 2.5% threshold. 21.1.1, application subject to 2.5% thresholds. Disapplication once you fall below it. And then there are masses of other differences, but to focus on 45.5, the expression to make good the shortfall is used in relation to what the principal employer and the trustee might, but were not obliged to agree within 3 months of the signing of the valuation. That's lines 3 to 8. With such agreement being required to be implemented through rule amendments, providing for additional contributions, reduction of benefits, or a combination of the same, or such other methods as might be agreed. Now, as is common ground, such rule amendments under the BRPS could have reduced the past service benefits of actives and deferred benefits. No friend didn't refer to this. In fact, a proviso to the amendment power of the BRPS would have prevented the taking away of pensions. Okay? But the important point is that there was nothing stopping the taking away of past service benefits for actives and deferreds. By contrast, Rule 21.1 STEM merely refers to what the designated and the employer might agree within 6 months by way of making arrangements. And as the appellants say at paragraph 37.2 of their skeleton, A9111, in their own view, it's unlikely that any past service benefits, not just those of pensioners, could have been could be reduced under such arrangements. Now, as the appellants have emphasised, for Rule 45.5, absent participating employer and trustee agreement, it fell to the actuary to determine the amount of such rate of increase in employer and member contributions as is necessary to make up the shortfall, such determination to be on the 60-40 basis. But the determination power, as we've seen in Rule 21.1.2, does not include the words as is necessary to make up the shortfall, and there is no basis for reading them in. And as we've seen from the near adjacent Rule 18E of the RPS, B13216, and the even closer Rule 21.1.1 of the RPS, B13219, the concept of making up the cost of something in full was not lost on the draftsman, but it was omitted from 21.1.2. And that the words, as is necessary to make up the shortfall, do not play a part in Rule 21.1.2 is emphasised by the 130% cap. It simply is not inherent in Rule 21.1.2 that contributions under it will be of an amount such, to quote Rule 45.5, as is necessary to make up the shortfall. And as we've noted, the 130% cap does not feature in Rule 45.5 of the BRPS. And that point is emphasised by the fact that Rule 21.1.4, which had no counterpart in Rule 45.5, recognises that contributions under Rule 21.1.2 may well not have been sufficient, may well have not been all that is necessary to make up the shortfall. So our final observation in relation to this is that the appellants really can't pick and choose as they do in this submission. To accept all the other features in respect of which Rule 21 differs from Rule 45.5, such as the 130% cap on which they rely, but then to cavil at the absence of the words "as is necessary to make up the shortfall" in 2, much less to require, as they do, that such words be read in. We say that the argument by reference to Rule 45.5 is impossible. Point 18. Finally, the appellant's actuarial arguments. These are introduced at paragraphs 67 to 72 of the appellant's skeleton, A9-121-2, and the trustees made certain observations in relation to them at paragraphs 37.3 and 37.4 of our skeleton, which perhaps you would be kind just to read to yourself. It's A10-137. A10-137. Paragraphs 37.3 and 37.4. So our submission in relation to this is that Atos's reliance, and I think I've already telegraphed this on a number of occasions, but Atos's reliance on the fact that the Rule 21 shortfall calculation, like the Rule 20 surplus calculation, contemplate the use of something in the nature of a prospective benefits funding method, takes them nowhere. All that a prospective benefits funding method is a method of deriving the actuarial valuation position of a scheme. Underline the actuarial valuation position of a scheme, which takes account of future benefit accrual and future contributions. In this respect, it's to be contrasted with an accrued benefits funding method, which derives the actuarial health of a scheme based on accrued benefits and past contributions. They are the two main categories of actuarial valuation bases of a scheme. And there are subcategories of such methods, which actuaries are free to choose between, and absent legislative prescription, for example, for the purposes of what is required for a scheme-specific funding valuation to comply with Part 3 of the Pensions Act, absent legislative prescription, there is substantial latitude for actuaries to adopt their own approaches to the valuation exercise in hand. All of this is well known. It's set out in GN 26 under headings 3 and 4 at D2 29 845 to 848. Now, your ladyship asked my learned friend yesterday, day 1, page 77, lines 9 to 11, where did the Chancellor err as to his treatment of GN 26, as had been introduced as a point by my learned friend a couple of pages earlier, page 75, line 17. The answer, actually, is that the Chancellor did not err in his treatment of GN 26 because my learned friend didn't take him to it. But the real point is this, and it's very, very important to understand. So as the final pushing to one side of this whole aspect of the case, there is nothing in a prospective benefits funding method or in any of its subcategories, any more than there is in any other funding method. There's nothing in a prospective benefits funding method or in any of its subcategories, any more than any other funding method, which entails, let alone justifies or endorses, the setting of uncollectible contributions as a method of making good a shortfall. A prospective benefits funding method is a method of calculating a shortfall or a surplus, or for that matter, whether a scheme is in actuarial balance. And like with all other actuarial methods in the pensions context, it will provide the actuary with a platform from which to advise whether, and if so what, by way of additional or continuing contributions should be required to address the shortfall, or as the case may be, to maintain the scheme in actuarial balance. But nowhere does the fact that the method happens to be a prospective benefits one involve, let alone support the proposition, that contributions as so set by the actuary, by way of redress of the shortfall, do not need to be collected. You've already, in the course of our point 6, had our submission that contributions are not a mere abstract mathematical construct, such as the appellants contend for. And I think we did have, if I may say so, the revealing exchange in the short adjournment that the 130% cap is not about hypothetical contributions, but evidently about the employer's unwillingness actually to pay them. The setting of contributions to be received is what makes good a shortfall, not the academic exercise of calculating them in the knowledge that the same will not be received, as would be the case here, or indifferent to whether there is a realistic prospect of their being received. And it's at the heart of the pensions actuary's function that contributions should not only be set, but they should be set with a view to being got in, because it's only by getting in contributions that liabilities are provided for and the actuarial health of the scheme is addressed. Now, the appellants put into the authorities bundle, but have really barely referred to, actuarial guidance notes and other materials, including GMs 26. But nowhere in that material will you find the proposition for which they contend in paragraph 67 of their appeal skeleton, A9121, and which my learned friend has endeavoured to elaborate in his oral submissions before you, that a prospective benefits funding method is satisfied by a theoretical mathematical making good of a shortfall. Contrary to the appellant's submission, a pension scheme is not ipso facto brought into balance by setting 1,000% section pay contributions under Rule 21.12, which will obviously not be collectible, and then stepping back and saying, well, that's all right then, there no longer is a Rule 21 shortfall. This is a parallel universe devised by the appellants for the purposes of this case. And as pointed out in the final sentence of paragraph 37.3, the hypothetical arithmetical making good submission is not even a submission that stands up in this case, where Atos has not agreed to lift the 130% cap. And those are the points made at paragraphs 2.8 to 220 of the of 213 of the Willis-Towers-Watson note that we looked at this morning, B22314, my introductory submission to you as to where we really are in this case. So we say that the appellant's contentions in relation to this particular point are an attempt, without expert evidence, to get this court to declare the basis of operation of a prospective benefit funding method as being satisfied by a theoretical setting of contributions, divorced from any consideration of whether there will be a practical getting in of contributions. And that, we say, is a matter of actuarial expertise into which your lordships should not be venturing without actuarial expert evidence, and certainly not without the assistance of an actuary. You don't have expert evidence. As it happens, you do have the assistance of an actuary. And just for your note, the appellant's attempt at first instance to anchor this submission, then made slightly less starkly than it was made in this court, in Appendix 2 to its trial skeleton, the manual, B20267, was critiqued by the scheme actuary at paragraphs 3.1 to 317 of his note at B22, 315 to 318. And the circumstances in which this note from the actuary was put in are explained in Mr. Sawyer's and my note to the Chancellor of the 4th of November 2022, which is at B22, 309 to 310, especially paragraphs 3 and 4 at page 310. So we could just look at that very, very briefly.
Mr. Sawyer, which tab was that?
B22, 309 to 10. And as we said in paragraph 37.4 of our skeleton, which I drew your attention, no objection was made to this reply. And to be honest, in the circumstances, none really could have been. And the critiquing, sorry, forgive me, I do apologise. The note is at 309 to 310, and if your lordships will just perhaps read it. The defendant's skeleton argument was received by us on the 28th of October 2022. You just skim 1 to 4. Well, actually, skim all of it, if you don't mind, 3 to 6. So you see at 5 and 6, and the actuary was expressing reservations about the propositions that were being put forward in the manual, and a concern, which I want to make a submission to you in relation to, not getting too into this, that there were potentially grave implications for what was said in the manual being accepted by a court and then extrapolated across the running of all the actuarial valuations of 106 shared cost sections in the future. And the actuary was very concerned about that. But the paragraph 6 point, that when we asked the appellants, how can you be putting this stuff in without actuarial expert evidence? Surely this is based on actuarial expert evidence. They said to us, oh no, our manual was actually produced without any actuarial expertise at all, as though that was a virtue. And we were obviously very, very concerned about that. So anyway, so those are the circumstances in which the critique was actually produced. And the critique, as I say, is at paragraphs 3.1 to 3.17 of the note, B22, 3.15 to 3.18. It's by no means comprehensive. But I just want to draw your attention to 2 points. First, the one which I've alluded to, at paragraph 3.1 and following of the actuary's note, B22, 315, he expressed a serious, a grave concern that the appellants were purporting to prescribe through the medium of their lawyer's note how Rule 21 works across the whole of the 106 sections of the RPS. And it was bad enough that any misconceptions in that note, with respect, might influence this case. But the notion that a lawyer's construct, as my learned friends admit, avowedly produced without actuarial advice, might, as a result of what is said by this court, impact actuarial practice in all 106 sections, was very concerning to the scheme actuary. And the second point is one which I've given you a reference to already, that a fundamental plank of the appellant's case, as picked up by the scheme actuary at paragraphs 3.9 to 310 of his note, B22316, is simply wrong. That fundamental plank is that taking account of opt-outs is not available to the actuary in the exercise of his professional judgment. And the actuary was very concerned about this because he regarded it as meat and drink. And that's paragraphs 3.9 to 310. So, concluding on that, that we say that the appellant's contentions that the fact that it just so happens that a prospective benefits funding method is mandated by Rule 21, therefore we're in the world of constructs and hypotheticals, and not a real world concerned with real people's benefits, contributions, and the like, is on it. I'm sorry, it's completely without foundation. And in our respectful submission, you shouldn't be deciding this case on the basis that it is the key to it. It's an entirely
Sorry, that it is
the key to understanding who's right in this case. In our submission, it would be entirely unsafe and unsatisfactory to do so. So that's our position on Rule 21, and I've no more to say in relation to it, unless I can assist you further. And I was going to move on to Article 7.
yes.
Oh, sorry. I'll deal with that. Article 7. Our points in relation to this are set out in the trustee's skeleton at paragraphs 13 to 31, at A10, 130 to 132, and further detailed, we're not going to go to them now, further detailed in the trustee's skeleton at paragraphs 68 to 74, A10, 146 to 148. And the court also has our comments in our supplementary skeleton, which I elaborated on first thing this morning. And I apprehend that, frankly, a lot of the heat has gone out of the Article 7 issue as a result of option B now being the appellant's preferred course. And that, frankly, the only issues in relation to Article 7 at the sharp end of the case are, one, the suggestion, which I looked at with you this morning, that the appellants might, for quantification purposes under Article 7.1, take credit for the contributions under Rule 21.1.2, the 0.9 million, which are not paid, and take credit for the elimination of the 5.3 million of future service benefits in reducing by 6.2 million, 5.3 plus 0.9, the 18.1 million Rule 21 shortfall. That point that I made to you at length this morning, which, based on the transcript reference yesterday, and also what my learned friend had said to you this morning. That's one of the sharp end points, and the only other sharp end point is as we regard it, entirely subordinate issue of whether Article 7 cuts in after Rule 21.1.2 or after Rule 21.1.4. Those, frankly, are the real issues. However, in order for you to anchor your decision on Article 7 on something firm, I do feel that I do need to say something to you more about it. And the first thing I want to say is to give you a reality check. The reality check is this. In recognition of the implicit state funding guarantee, which had underlain the BRPS, on privatisation, ex-BR pensioners and deferreds received an absolute solvency guarantee from the government. And that's referred to, and that's how it's referred to, in Mr. Montague's letter at A318. Now, here's the point, the reality check. The concern that underlay the provision of that guarantee for ex-BR pensioners and deferreds was assuring the sufficiency of funding of their accrued benefits whilst in public service. That consideration was equally applicable, not merely in logic, but also in political and industrial relations reality, in relation to providing an assurance as to the sufficiency of funding of accrued benefits of ex-BR active members. The 20 to 30 years of accrued benefits that an active member might have under the BRPS no less merited some sort of sufficiency of funding protection than, say, the same 20 to 30 years accrued benefits of an ex-BRPS pensioner or deferred. And further, it was a small step from recognition of that as a matter of logic, and it involved no further step as a matter of political and industrial relations realism for some form of solvency assurance also to be regarded as important in relation to the further benefits that such persons would have accrued in the public sector with the implicit government guarantee had privatisation not occurred. The risk which underpins Article 7, the risk was that with privatisation, ex-public sector railways employees, unlike their pensioner and deferred counterparts, should be left with unfunded accrued benefits in a shortfall situation. And that risk extended to any future accruing benefits, which would be similarly unprotected because of privatisation. And that was a serious issue of its time. And that's where Schedule 11, paragraph 7.1f of the Railways Act, which we're going to look at, and Article 7.1 come from. And you actually see the concern being ventilated in the Memorandum of Understanding from the 28th of July 1993 that the appellants have put in at B1. I'm not going to take you to it, but if you read the document, you'll see that the same sorts of concerns and considerations as applied to existing and deferred pensioners were recognised as applying to future BR pensioners. Actually, I will take you to it if I may. B1, 6 to 7. Actually, we can pick it up at B1.5, just at the opening sentence. The government, the BR Pension Trustee Company and the BR Board share a concern that the pensions of existing deferred and future BR pensioners should be fully protected after privatisation. Future BR pensioners. This is early days, 28th of July 1993. 4 months before the Railways Act, Pension Protection Order, 31st of May 1994, Protection Order not even referred to. Page 6, future BR pensioners. The arrangements outlined will, for existing and deferred pensioners, underpin the government's undertaking that the treatment of pensioners after privatisation will be fully safeguarded. The government recognises that this safeguard should extend to those who leave BR employment after the establishment of the closed fund. At that point, those continuing in employment with BR will belong to the BR section of the joint industry scheme, i.e. what was the open section, how it all started. And they will receive precisely the same benefit entitlements as present. And then there's the recognition that special arrangements may be needed to provide continuing safeguards. The first bullet point is the no less favourable guarantee. No doubt about that. We've got no problem with the no less favourable guarantee. But look at the second and third bullet points. These are the early days recognition of solvency safeguarding being important in the joint industry scheme. It turned into Article 7 of the Pensions Order, Protection Order. The government actuary will be a joint actuary of the BR section of the joint industry scheme if the joint actuaries certify the instability of the fund. The Secretary of State shall be under a duty to consider how to secure the delivery of the government commitment restated above and to take steps accordingly. This is where Schedule 11, paragraph 7.1f and Article 7 of the Protection Order came from. Thinking better, developing the thinking, this is where they came from. Article 7. Point 1. One starts with Schedule 11, paragraph 7.1f of the Railways Act.
I'm so sorry, I've just changed notebook. So, point 1, Article 7.
So point 1, one starts with Schedule 11, paragraph 7.1f of the Railways Act, and that's B10117. And as your lordships will see, or have already seen, but I want to more minutely analyse this provision and its the predecessor paragraph. Article 7.1 owes its authority to Schedule 11, paragraph 7.1f, and that provides that without prejudice to the generality of Schedule 11, paragraph 6, which is at page 114, we'll look at that in a moment, an order under paragraph 6 may impose on any employer duties with respect to F, the making of contributions, employers being the relevant categories of person for this purpose, as referred to in paragraph 7.2a and b on B10117. Now, the generality of what is provided for under Schedule 11, paragraph 6, to which paragraph 7 is without prejudice, is contained in Schedule 11, paragraph 6.1. That's B10114. The general point, and is the Secretary of State may by order make provision for the purpose of protecting the interests of protected persons in respect of their pension rights. The words no less favourable do not feature in the generality of the power to provide protections enacted by Schedule 11, paragraph 6.1. Schedule 11, paragraph 6.2a and b, page 114, set out specific examples of what might be provided for under a protection order by reference to a no less favourable standard. Such examples themselves also being expressly stated to be without prejudice to the generality of subparagraph 1. 6.2a referred to securing no less favourable relevant pension rights of protected persons in relation to amendment, transfer and winding up. 6.2b referred to precluding prevention of protected employees from participation in an occupational pension scheme so as to acquire no less favourable rights. Now, Schedule 11, paragraph 7.1, returning to that, taking its authority from the generality of paragraph 6.1, was clearly making provision separate and in addition to Schedule 11, para 6.2. And just as in the case of Schedule 11, para 6.1, the words no less favourable nowhere feature in Schedule 11, paragraph 7. Indeed, it is clear from Schedule 11, paragraph 7, paragraph 7.1, that its reach is wider than the specific no less favourable protections of pension benefits referred to in Schedule 11, para 6.2. Because when you look at Schedule 11, para 7.1 A to H, it deals not only with matters not addressed in paragraph 6.2, but it also contemplates the possibility of protections in relation to matters referred to in paragraph 6.2, unrestricted by a no less favourable concept. See the references to protections from amendment and winding up in paragraphs 7.1c and H, and indeed, as regards provision of a pension scheme generally, 7.1a, this last bearing on prevention from participation. Schedule 11, paragraph 7.1 introductory words is clear. A protection order when made might, in relation to protected persons, under its terms, impose its own duties on employers. And subparagraph F makes clear that the duties that might be imposed on employers in respect of protected persons under such an order include duties as to the making of contributions. That is, duties falling not on what might be described as the benefits side of the line, to which no less favourable protections were addressed, but duties falling on the contributions side of the line. The duties imposed on employers to make contributions protecting the interests of protected persons under Article 7.1, as well as under Article 7.4, owe their separate existence and authority to Schedule 11, paragraph 7.1f, accordingly. Point 2. Then to Article 7.1, B11, 145 to 6. Article 7.1 imposes on employers in the scheme or section in which protected persons are interested an obligation to make contributions of a particular measure. That is, the Article 7.2 measure, contributions sufficient to make provision in respect of accrued and accruing pension rights under the scheme or section in question. I should say the Article 7.1 and 7.2 measure. Contributions sufficient to make provision in respect of accrued and accruing pension rights under the scheme or section in question. And consistent with Schedule 11, paragraph 7.1f, the addressee of the obligation set out by Article 7.1 is the employer and the employer alone. Now, it's important to note, and the fact is, in light of option B, it's common ground, it's important to note that the obligation is placed on the person having a duty, indefinite article, a duty to contribute to a section, whatever the duty to contribute. See line 2. Article 7.1 does not say this article only applies where the person having the duty to contribute has a balance of cost obligation to contribute. And the appellant's attempt only very faintly revisited, when my friend was on his feet, at paragraphs 26 to 34 of their skeleton, that's A9 107 to 110, to restrict Article 7 in this way, as though it's concerned with the potentiality of balance of cost schemes that might come along at some point in the future if employees cease to be employed in the railways industry, and so they lose their indefeasible right to be members of the RPS, and some balance of cost arrangement might be put up in its place. That suggestion is unfounded. There's no basis for saying that Article 7 was only envisaged as applying to schemes other than the RPS, which might conceivably come into being in the future and be balance of cost in nature. It's not what is provided in Article 7. And the fact is that the RPS was the scheme underlined, being the designated joint industry scheme under Article 3 of the RPS order, B424, into which protected persons were going to be and were transferred against a backdrop of their being provided with an indefeasible right. And this is important, what I'm going to say to you. They had an indefeasible right not only to be members of the RPS, that's Article 11.1 of the pension order, of the protection order, B11.150. So if you please turn that up, B11.150. Not only did they have an indefeasible right so long as they were employed in the railways industry and were ex-BRPS, not only did they have an indefeasible right to be members of the RPS, Article 11.1, Article 11.5, 151, they also had an indefeasible right to be a member of a shared cost arrangement. And as we know, the RPS order and the pension protection order were made on the same date. So the suggestion that Article 7 was not intended to apply to the shared cost arrangements under the RPS, frankly, is implausible and unrealistic. The suggestion that it might have been there in order to apply to balance of cost schemes is unrealistic. Now, as I say, I appreciate that my friend didn't really run with this, but I think it's important for your lordships to be able to anchor any decision you make on in relation to Article 7 on firm ground, if I may say so. And then back to Article 7.1. What Article 7.1 then goes on to provide over the page at line 3, B11.146, we've looked at this already, is that the contributions that employers shall make under that duty, i.e. pursuant to that duty, whatever that duty, as we've seen from line 2, shall be, or may be, those contributions shall be sufficient to make provision in respect of accrued and accruing pension rights. And as to this, it is important to note, as we have already picked up in analysing Rule 21, that such a sufficiency standard is nowhere provided for in Rule 21 itself. And that provides a further reason, this will be my point 5, that the sufficiency standard is not a feature of Rule 21. Hence Article 7 was operating outside it. And that provides a further reason for the conclusion that Article 7.1 is providing a further layer of obligation on employers having a contributions duty under the RPS, where there are protected persons, and not one circumscribed by, let alone satisfied by, what is provided by way of shared cost in Rule 21. The contribution, final sentence on this, the contributions duty gateway to the application of Article 7.1 in this case is that imposed by Rule 3A. It is the fact of that duty the employer's duty under Rule 3A, not any particular amount that is being paid pursuant to it at any given time, or the limb of Rule 3B by reference to which the employer is for the time being obliged to make payments, that constitutes the gateway to the application of Article 7.1. So you'll have seen that under Rule 3B, Rule 21 contributions are entertained, and the employer has obligations to pay a multiple of those under Rule 3A. Under Rule 3B, non-Rule 21 member contributions are entertained, and the employer has a duty to make contributions in relation to them under Rule 3A. That's the A duty, which is being referred to under the relevant heading.
Right, that's a convenient point to stop. What have you got left for the morning?
I was going to take up all the time that I have.
Well, I'm sure you are, Mr. Green.
I need to look at the chat.
What subject matter have you still got?
I've got further development of our points on Article 7, through to the concluding point on where it fits in relation to 21.1.2 and 21.1.4, and then I've got Article 5, and then I'm done.
Yes. And at what point does the chess clock operate to hand over to Mr. Spink?
That's what we've got to look at quickly after this hearing. But Mr. My learned friend, as he said this morning, had 38 minutes in theory before you. In fact, he sat down at, I think he started at about 10:03, I think, and sat down at 11. And he was also shaking his head at the precision. He sat down at 11. So that effectively gave us, I think, a bit more time as a result of that. And we need to look at the exact finishing time, but we're on for 12:30.
We are finishing at 12:30.
No,
Good. Okay, 10 o'clock tomorrow then.
Thank you so much. Oh, my lord, forgive me,
Yes.
I do apologise.
Yes.
We've managed to put together, sorry, we have the list of examples of the word determined.
Determined, yes.
Yes. Now, this is in the form of a printout produced by Slaughter and May. So, thank you.
I thought this was going to be a couple of pages.
No, it's not. But that's, as I said, there are many examples. But my learned friends have not had a chance to look at it in order to say
we
that it is.
probably shouldn't either then.
Well, no, well, that's fine.
May I help on this?
Yeah, please.
But you should take it away with you.
Right.
What happened was, originally this was our document produced yesterday and sent last night.
Right.
We received it back at 1:20 during the luncheon adjournment.
Yes.
Unfortunately, instead of simply applying tracked changes to our document so that we could be sure that the only things that might be different were easily highlighted, it was put into a completely new document. We were, I'm pleased to say, told what the changes were. We looked at those changes and they are acceptable.
Good.
They were very minor.
Well,
We
now,
will need
now,
to
now
check
that
the
I've
rest of it at greater length.
Now that
But
I've
that is
glanced
fine.
at it, it doesn't seem to argue any cases.
No, it
It's
doesn't.
a list.
No. It's any issues that arise will be very minor and will not affect the thrust of it and the usefulness of it for your lordships.
Thank you very much. 10 o'clock tomorrow.
I'm so sorry.